While we presume prospective jurors to be impartial, even if there is a basis to inquire into partiality, we also consider individuals that come forward to fulfill an important civic duty to be worthy of respect, and courts are very alive to protecting the privacy of individuals and not wading into that privacy for any purpose beyond assuring that the individuals on trial receive a fair trial.
Wednesday's proceedings in the trial for the Coutts Three, Marco van Hugenbos, Alex van Herk, and George Jansen, came to an end. This is the first day that we've seen the jury in the courtroom all together as one. They were selected yesterday. This is Robert Kraychik in Lethbridge, Alberta, reporting for Rebel News. The three defendants, the Coutts Three, aka the Coutts Trio, Marco van Hugenbos, Alex van Herk, and George Jansen, they're all being charged with mischief over $5,000 for their involvement, their participation in the Coutts border blockade protest. They're being characterized as the leadership of the protest, and the prosecution is seeking to argue to convince the jury that these three had a degree of control over the protesters and therefore hold a unique degree of responsibility over what they allege was a criminal, unlawful protest. Just a little bit of background, this protest was sort of adjacent to the Freedom Convoy protest of 2022 in Ottawa, Ontario. The two protests overlapped temporally and both broadly shared ideological and political objectives in that they were broadly opposed to what I refer to as the COVID-19 enterprise, this apparatus of surveillance and control, governmental and institutional edicts, mandates, orders, ostensibly issued to protect so-called public health in response to COVID-19. The jury was selected yesterday from a pool of prospective jurors, and the screening process entailed the judge asking them a series of questions to determine whether or not there was any risk of partiality. In other words, to ensure that they could conduct themselves impartially and render a fair verdict if selected to become jurists. I've come to understand that the questions that are asked by a judge of potential jurors in this screening process are determined via negotiation between the two opposing parties. So both the Crown and defense negotiate over the nature of the questions and their composition. And the judge has final discretion over determining whether or not these questions are accepted. So the first question that was asked of all prospective jurors, and this is nearly a quote, was, have you been, or has anyone close to you, been affected by COVID-19? And I'll share with you some concerns that arise with the phrasing of that question. Those of us who consume a lot of political news media content or who have a lot of political conversations will know that COVID-19, that term, in the vernacular, colloquially, is used as a euphemism very often in reference to governmental decrees, orders, mandates, and edicts issued ostensibly in pursuit of so-called public health in response to COVID-19. We've all heard people say things like before COVID-19 or COVID-19 did this or did that. They personify COVID-19 as if the virus itself or the syndrome had agency and somehow led to closures of businesses or mask mandates. In other words, the lack of clarity over the use of that term, and none of the jurors asked for clarification over what was referred to by COVID-19, whether it was a specific reference to a virus or syndrome, or whether it was a euphemism or catch-all phrase for what I refer to as the COVID-19 enterprise, was problematic in that it is likely that jurors cannot fully comprehend what was being intended by that question. The prospective jurors were also asked whether or not they had any strong attitudes or feelings in support of or in opposition towards the Coutts border blockade protest. They were also asked whether or not they had any strong attitudes supportive of or in opposition to any persons charged with or convicted of offenses related to the Coutts border blockade. Today's proceedings were primarily consumed by two items. The first being the judge issuing his instructions to the jurors, how they must conduct themselves and restrictions, how they must restrict their deliberations to evidence presented in the courtroom and not information that they may consume elsewhere, for example, the internet or friends or family, and also how they must abide by his instructions as the judge. And secondarily, we began to see the questioning of the first Crown witness, a man named Jim Willett, former mayor of Coutts, and he operated in that capacity as mayor of that village during the Coutts border blockade. And the questions revolved primarily around his observations of the Coutts border blockade while he was mayor. And presumably the prosecution is seeking to establish his credibility as a witness. But the only remark that really jumped out at me that I think was noteworthy that I want to relay to you folks out there in the Dear Rebel News audience is what the former mayor of Coutts said in his testimony about the protesters. So as the protesters began to arrive in his village, he said that a lot of strangers, that's a quote, coming to his city, his village, I should say, alarmed him and made him more guarded. He went on to say that he advised fellow Coutts residents to, quote, lock their doors and, quote, keep their kids off the streets. In other words, he was relaying this sense, this attitude of concern and alarm regarding the arrival of freedom-minded Canadians protesting against the COVID-19 enterprise. I think that's indicative of this man's political, ideological, and philosophical attitude, and perhaps secondarily is revealing of the types of news media sources that he relies on to build his understanding of reality. Okay, so I'm here with Michael Johnston, who's representing Alex Van Herk, and I want to ask Michael a general question about how questions for screening on impartiality are determined, that are asked of potential jurors by the judge. And secondarily, maybe you can tell the audience if there are any types of questions that are disallowed, that are seen as too invasive or private to be asked as part of a screening process to determine partiality or screen for partiality on the side of potential jurors.
Well, in some ways, those two questions are interrelated. And they're interrelated because when you bring what's called a challenge for cause and you're challenging, let's say, the entire panel based on impartiality or potential partiality, what needs to happen is there needs to be a pre-showing. There needs to be a demonstration that the presumption of juror partiality is rebutted. So you have to show that there's a realistic potential for partiality that may not be cured by the guards or the protections or procedures that exist in the system, things like judicial instructions, etc. So first and foremost, there needs to be a showing that there is a basis to challenge jurors for cause or potential jurors for cause, because they're not jurors until they swear an oath. And the nature of the alleged or the realistic potential for a type of partiality will be the determining issue in terms of what types of questions can be asked. One of the things that's important to bear in mind in Canada is that we don't have as far-reaching a voir dire process for impaneling the jury as they do in the U.S. They don't approach juries and jury selection in the same way as we do. Again, as I stated, jurors are presumed to be impartial. And even if you can rebut that and show that there's a realistic potential and therefore you're allowed to ask the questions, we still respect jurors' privacy quite a bit more. So we want to make sure that sufficient questions are being asked to determine whether or not there is an attitudinal issue disclosed with a potential juror. And if that attitudinal issue is disclosed, then you ask generally a follow-up question pertaining to that behavior. So the correlation is if you have a problematic attitude, let's say one of the bases for alleging potential partiality is racial bias. So you would first ask a potential juror whether or not a a witness or an accused person or a participant in the trial being of a particular racial denomination or religious orientation would affect them? Do they have a preconceived notion about individuals of that race or religion or culture? And if they do, generally the follow-up question would then be, well, having that preconceived opinion, would you nevertheless be able to set that opinion aside and try this case impartially? So in a different context, if the basis for questioning a juror is, or a potential juror, is pretrial publicity. For example, a case has received widespread commentary in the media, and perhaps even politicians have commented one way or another. Questions that are going to be permitted pertain to whether or not there has been exposure to the source of pretrial publicity, and whether in being exposed to the pretrial publicity that has occasioned an opinion about the guilt or the innocence, or just an opinion in general, whether you ask about the guilt or the innocence. And if there is an opinion, having that opinion can nevertheless be set aside, and can the person well and truly try the case and render a verdict according to their oaths and the evidence. If counsel are in agreement on both sides that there is a realistic potential, then there can be a crafting of questions as between counsel, and then ultimately it's in the discretion of the trial judge if they accept what has ultimately been crafted between various parties.
One quick follow-up question. You mentioned several bases of potential bias. You mentioned racial bias. You mentioned cultural. Is that something that has ever arose? Is that something that could ever be inquired about in screening of potential jurors for bias? Like, hey, do you vote for this person? Hey, how do you think about this particular political issue? Have you seen those sorts of questions used in screening potential jurors for potential bias or lack of partiality in a trial where politics may be a central theme or a germane issue?
I personally have not seen that, and I've done a bit of research in the area, so my experience is anecdotal and only extends as far as I've been able to research or otherwise document. But generally, I would say that that's the type of area that the courts would shy away from. And that goes back to the notion of, while we presume prospective jurors to be impartial, even if there is a basis to inquire into partiality, we also consider individuals that come forward to fulfill an important civic duty to be worthy of respect, and courts are very alive to protecting the privacy of individuals and not wading into that privacy for any purpose beyond assuring that the individuals on trial receive a fair trial, right? That's gotcha. It's not about crafting or manicuring a jury that's going to agree with your politics. It's just about finding fair individuals who represent a cross-section of society, can fairly be said to be representative of the conscience in the community. And similarly, it's jury selection and the use of questions isn't some opportunity to begin to indoctrinate the jury to your point of view. So it's very much, in my experience and based on what I've been able to see, not an area that I believe the judiciary would permit you to engage in, unless it really could be heavily tied to some form of partiality that might be manifest, such that the person on trial couldn't receive a fair trial. But I just haven't seen that to date.
Folks, we're running two fundraising campaigns in relation to this trial. One is to offset the legal costs for the defendants. Remember, lawyers don't work for free, and they are definitely not cheap. You can visit Coutts3.com and make a donation. And if you do, you'll receive a charitable receipt for that generous donation, because this fundraiser is being administered by our partner organization, a nonprofit organization known as the Democracy Fund. Secondarily, we're running a fundraising campaign to get me out here from Ottawa. So while Lethbridge is not Miami, or New York City, it's not free either. I took economy airfare, rented a car, I've got an economy Airbnb, and we are dependent on your generous support in order to continue producing this in the field, independent, original journalism and reporting that you're not going to get anywhere else. So if you want to help us out, please visit truckertrials.com.